Senator, thanks for being with us today.
As to you and Jason, y'all have done more to educate the American public about the true state of the law than anybody. Thank you.
Well, I appreciate that. Joining me in the studio, by the way, Senator, so you know, we've got David French, who is our senior counsel and also a Judge Advocate General in the Army, and Skip Ash, who served also in the Army, and you're, of course, Air Force. So we got Air Force and Army here. I want to ask you the question. The pressure right now is, you know, are they going to Mirandize this accused? Give me your expertise again so people understand what should happen here. Not what will happen, but what should happen.
Okay, the public safety exception to Miranda is of a limited duration. It was the N. Ray Quarles case. You had a rape suspect who had a holster with a missing gun. So the court said they could talk to the suspect about where the gun was. The public safety exception is not an interrogation system. It is a way to secure the crime scene. Now, we've got two legal systems in play here. The criminal justice system. The public safety exception to secure the crime scene is of limited duration here. I want to gather intelligence. Don't you think the American people want to do two things? Bring the guy to justice and find out about future attacks. Here's what will happen. If you're going to ask him questions about his innocence or guilt, the public safety exception is very narrow. Eventually, to do that, you got to read him his Miranda rights, because if you're trying to find information to convict him in court, he deserves, like every other criminal defendant, to be represented by counsel and not to incriminate himself. A first-year law student could prosecute this guy.
Absolutely.
What are we concerned about? We're concerned about the national security side of the case. We're concerned about interrogating him for the purposes of finding out about future terrorist attacks and who he may have associated himself with. Under that system, to gather intelligence regarding a future enemy attack, there is no lawyer required. And to use the criminal justice system to gather intelligence would be a mistake, because if that's the only way we can gather intelligence, you're turning control of the system over to the terrorist and his lawyer. We can't ask any question that the lawyer doesn't agree to be asked. Under my construct, interrogating him for national security purposes, no lawyers required. We're not going to use the evidence against him in court. We're going to use the evidence and information to protect the nation. He will be tried in federal court. He's not eligible for military commission tribunal trials because I wrote the law in 2009. He's an American citizen. He has to go into the federal or state system. In this case, I think the federal system is the right system. But what I'm talking about is a legal system designed around national security that would allow us to interview him and anybody else we think may be involved in an attack against the nation.
We have a situation right now where the evidence against the accused and his brother are overwhelming. We've got the video of him placing the bomb. I mean, the admission to the person where they carjacked the car. We're not real. Like you said, this is a first-year law student in a moot court case could handle this prosecution. The issue is, as you said, Senator, so directly and eloquently, is the intelligence gathering. That, to us, is the critical part of this as well. And I've been involved in some of these cases, and my concern here is we're in limbo right now. We've got the Justice Department has not Mirandized the individual, but they've not yet declared him an enemy combatant. What do you sense, and what are you urging happen right now with the Justice Department? You got the ACLU screaming about, he needs to be read as Miranda rights right away. But what are you asking the Justice Department and the President to do here?
Let's just tell you what I would do if I were president.
Okay.
I would say there's enough evidence to suggest this was an attack against the nation, a slaughter against the innocent, motivated by radical ideology, Islamic ideology. They didn't attack a bank. They weren't trying to steal property. They weren't trying to commit a traditional crime. They were trying to kill innocent Americans because they consider us infidels. They were motivated by radical Islamic ideology. They're tied now to overseas areas that are hotbeds for radical Islam. I would say there's enough evidence to suggest he is a potential candidate for an enemy combatant determination. I would allow the FBI and the CIA to investigate the intelligence side, talk to him as an enemy combatant. And here's what enemy combatants have available to them. If the government says you're an enemy combatant, you're associated with radical Islamic organizations, that are deemed to be military threats to the country. You can petition to a federal court
Right.
through habeas review, and the government has to prove to a federal judge they have enough evidence to hold you as an enemy combatant. So he's not without legal rights. But we can't decide this by Tuesday, and the public safety exception under Miranda is meant for hours, really not days.
Yeah, I mean, the most you're hearing about is 48 hours, which when does that apply? When he was cognizant and awake, or is it when he was captured? I mean, it's just fraught with
But
harm.
here's what I do know. There is, under the law of war, and if you believe we're at war like I and you,
Right.
that both of us do, then we have a right as a nation to defend ourselves. So the enemy combatant interrogation system is designed not to convict someone in a court, but to protect us against future attacks. And my belief is that we should have the ability to take some time here to figure out if he fits into that definition. There's plenty of evidence to suggest he may. And I don't want to turn over the interrogation process to his lawyer and the terrorists themselves. So that's what I would do if I was the Justice Department. I'd say, listen, there's enough evidence to suggest that he may well be involved with radical Islamic organizations we're at war with. Let's take the time to make that case.
And Senator, there is no inconsistency, and I think this is an important. I know you were talking about this weekend. I watched you often this weekend. There is no inconsistency with the declaration of enemy combatant status and Article III courts for ultimate disposition of, in fact, a trial if we decide to go that route.
As a matter of fact, the only trial venue available to this guy is a state court or an Article III federal court. I wrote the Military Commission Act in 2009. I've been a military lawyer for 30 years. I want to reserve military commissions for foreign terrorists. When it comes to American citizens who side with the enemy, here's the law. There are three cases very much on point, and the two JAGs will be familiar with this as basic military law here. In World War II, you had German saboteurs who landed in Long Island. They got off a German sub, they landed in Long Island, and they were met by people inside our country who were sympathetic to the Nazis. Some of them were American citizens. The FBI stopped the plot. They arrested all those involved, including the German saboteurs. Several of them were American citizens. They were tried by a military commission back then and hung. Their case went to the Supreme Court, and the Supreme Court said, we're not fighting a crime, we're fighting a war, and therefore an American citizen who aids the enemy can be considered under our law, under the law of war. American citizenship doesn't give you immunity from having the law of war applied to you. It's not a constitutional right to help the enemies of our country. If you engage in hostile acts, then you can be subject to the law of war. Okay, we got Hamdi versus Rumsfeld. This was an American citizen captured in Afghanistan. The Supreme Court ruled in 2006, like in World War II, we can hold one of our own as an enemy combatant to protect the nation who's at war. You have Padilla, who was held in Charleston for 4 years, an American citizen collaborating with al-Qaeda. His case went to the Fourth Circuit. The Fourth Circuit said the government has a right to hold an American citizen collaborating with the enemy to keep them off the battlefield. He was later charged in civilian court. Those three cases stand for the proposition that an American citizen who engages in hostile acts and aligns themselves with the enemies of our nation when we're at war can be treated under the law of war.
Senator, I want to say thank you. Thank you for the explanation, which was crystal clear. Thank you for your experience in our military, and thank you for taking the stand you're taking on this particular act of terror against the United States. It's always a pleasure to have you on, and I appreciate your clarity.
One last thought. It would be very tragic if our nation cannot have access to a terrorist like this and question them about future attacks without having to go through a lawyer.
Absolutely.
That means we're not at war. I think we are, and that would be an absurd outcome. And to those who have served there with you, thank you for your service.
Thank you, Senator. Senator